Hello everyone, a very good evening and welcome to Byju's Exam Prep. Welcome to our weekly current affairs webinar. Every Tuesday, we cover all the important current affairs developments of the last 1 week. And as you know, the Tuesday webinar is largely prelims oriented. So we will focus on 9 important topics in today's discussion and we'll try to pick out all the important facts and concepts that are important for your prelims exam. Of course, these topics will be relevant for your mains as well because UPSC never draws a clear distinction between prelims and mains topics. The discussion will be prelims oriented, but wherever necessary, especially in some of the big topics, I will try to bring in analysis and a discussion as well so that you can prepare for these topics from the mains perspective as well. So let's get started with the first topic for today, starting with the Biological Diversity Amendment Bill that was in news over the last week. First, let's understand the context as to why the topic was in news. Last week, the Lok Sabha has passed the Biological Diversity Amendment Bill 2021. This bill was drafted in 2021 after a lot of debates and discussions. Finally, the bill has been passed in the Lok Sabha. So let's understand everything about the Biological Diversity Act, which was enacted back in 2002. And let's also talk about the amendments that have been done during the latest amendment. So this bill amends the Biodiversity Act or the Biological Diversity Act of 2002. This amendment was required because several stakeholders had raised concerns about the existing act. In the Biological Diversity Act, which was implemented over the last 20 years, a few discrepancies had come up with regard to its implementation and with regard to its impact on the stakeholders. There were few drawbacks in the previous act. That is why this amendment became necessary according to the Government of India. So all the concerned ministries, particularly the Ministry of Environment, Forest and Climate Change, along with the National Biodiversity Authority, and as well as from the industry, from research institutions, there was a long-standing demand that this law had to be amended in order to fix some of the gaps and shortcomings that were present in the act. So it's in this context that the Biological Diversity Act was in news because the Biological Diversity Amendment Bill has been passed by the Lok Sabha. Now, let's begin with the basics. Now that we understood the context, let's understand what is biodiversity. What are the different levels in biodiversity? And let's understand why biodiversity conservation and protection is important. Based on that, we'll talk about a UN convention. We'll also discuss the Biological Diversity Act and the key institutions it had created and set up. Then we shall look at the amendments which have been carried out and we'll compare the new version of the law with the previous version of the law. We'll also look at the arguments of the government, why the government has justified the amendments, and we shall also look at the criticism. Because this amendment has triggered a debate, especially from environmental experts. There has been a lot of criticism against the amendments which have been done and thoroughly cover this topic. So let's begin with what is biodiversity. Biodiversity is nothing but the diversity of life, the diversity of all life forms present on Earth. This includes animals, birds, aquatic animals, and even the microorganisms. They represent the variety of life on Earth. Is that clear? Variety of life is nothing but biodiversity, the diversity in biological life forms. So the different species of animals, birds, plants, and microorganisms, that constitutes your biodiversity. Understood? And this biodiversity can be measured at 3 different levels, which is represented here in this pyramid. Ecologists and researchers, They have categorized biodiversity to be present at three different levels in our ecosystems. The bottommost level is genetic diversity. That is, within every species, the genetic diversity will determine the diversity of that particular species. Now, take human beings, for example, or any animal for that matter. Each individual looks different. They'll have different characteristics, different traits. This is all because of the genetic variations present within a particular species. So this constitutes genetic diversity, which forms the very foundation of biodiversity. Genetic diversity amongst different species gives rise to the next level of biodiversity, that is species diversity. The number of different species present in our planet. This is based on genetic diversity within each species. So genetic diversity contributes to species diversity. If genetically species are diverse, it gives resilience to each species to withstand the impact of disasters and hazards and other stress factors. As a species becomes more resilient, as it can withstand the stress factors in the nature, it will evolve, it will become a stronger species, and it will contribute to the entire food chain and the ecosystem. So genetic diversity in turn contributes to species level diversity. At the level of different species, you'll start witnessing more diversity. You'll witness different kinds of animals, different kinds of plants, birds, microorganisms, etc. So if the species thrive, if we have a variety of species present, this will give rise to ecosystem diversity. At the ecosystem level, at the top level of the pyramid, you'll start witnessing ecosystem diversity, where our ecosystems will become diverse. Each ecosystem will contain a diverse set of life. Is that clear? For example, in the Arctic ecosystem, in the marine ecosystems, in our tropical ecosystems, we have very rich variety of life that adds to biodiversity that is found on Earth. So biodiversity, which is the variety of life on Earth, is a factor of all the three levels of biodiversity. That is genetic diversity, species diversity, and ecosystems diversity. If we are able to protect this diversity at all three levels, it will make each species, each ecosystem more resilient to the impact of stress factors. They will continue to evolve and become a stronger species that can survive and contribute to life on Earth. But as you know, anthropogenic activities, that is human activities, they have adversely affected our biodiversity. Industrialization, exploitation of natural resources, especially forest resources, hunting and poaching, burning of fossil fuels, all these human activities, including pollution, the release of toxic materials because of industrial activities, they have all had an impact on our biodiversity. We have damaged ecosystem diversity, species diversity, and even genetic diversity because of human activities. That is why it becomes very important to conserve and protect our biodiversity. Because any impact on one species will affect the other species as well. Impact on ecosystems will affect other ecosystems as well. Impact on genetic level diversity will compromise the strength of that species, and in turn affects the food chain and other species and ecosystems as well. So we live in an interconnected world. We share a connection with our environment and with our ecosystem, right? Inevitably, we are all linked to both the physical, the inorganic components of our ecosystems, and as well as to the organic life forms. So this connection, if it has to be preserved, if it has to be protected, we need to focus on our human activities. We need to restrict some human activities, regulate them in order to conserve and protect our biodiversity. So this forms the basis of the Biological Diversity Act that was enacted in 2002 by the then Vajpayee government. Is that clear? The act was brought out to conserve and protect our biological resources, to protect our biodiversity within our country at all the three levels, that is genetics, species, and ecosystem diversity. This was the prime intention, the prime objective of the law. This law was enacted in India to fulfill an international obligation. India had an international obligation to fulfill under the UN Convention on Biological Diversity, or also popularly known as the CBD Convention. Is that clear? In the year 1992, a very important summit was organized through the United Nations, which is the Rio Earth Summit. I'm sure you guys would have studied this under environment and ecology. The Rio Earth Summit was one of the landmark summits hosted by the UN in the field of environment and ecology. The Rio Earth Summit recognized the impact of human activities on our environment and biodiversity, and it gave rise to three important UN conventions. Three important UN conventions were born through the Rio Earth Summit. Do you guys know which are these three conventions? Can you let me know in the comments? Can you let me know which three conventions were established following the Rio Earth Summit? UNFCCC, very good. That is the Climate Change Convention. Then the UNCBD, the Convention on Biological Diversity, which we just mentioned. And the last one, the Convention to Combat Desertification. Very good. Three important conventions were brought out through the Rio Earth Summit. The UN Framework Convention on Climate Change, or also called the Climate Change Convention. Right? Every year the Climate Change Convention meeting happens, the Conference of Parties takes place, and we have climate agreements like Paris Agreement, Kyoto Protocol, which are part of this Climate Change Convention. So Climate Change Convention, or UNFCCC, is mainly focused on reducing greenhouse gas emissions in order to counter climate change and global warming. The other important convention adopted was UNCBD, UN Convention on Biological Diversity, that is to conserve and protect our biodiversity. And the third one was the UN Convention to Combat Desertification. As desert areas were expanding and land was getting degraded because of deforestation, a UN convention was brought out to counter desertification and promote afforestation. These are the three important conventions that were born out of Rio Earth Summit, and the UNCBD laid down three global goals to conserve and protect biodiversity. So India is party to all the three. We are party to all the three conventions. Is that clear? And in order to implement this commitment to the CBD convention, we had to ensure that these goals of CBD convention are realized in India through a law, through a national legislation. According to the CBD convention, the three goals includes conservation of biological diversity, sustainable use of the components of biological diversity, fair and equitable sharing of the benefits arising out of the utilization of genetic resources and associated traditional knowledge. These were the three goals laid down under the CBD convention. The first goal was to conserve, to protect the biodiversity that we have. That is to counter hunting and poaching, to minimize the stress on our forests, on our ecosystems, and to protect the different species that we have, to protect all the life forms on Earth. Second objective was to promote sustainable usage. Because see, human well-being is dependent on our natural resources. For food, for socio-economic development, for economic growth, for all of this, we have to rely on our natural resources. But this should not turn into over-exploitation. We should not abuse our biodiversity and ecosystems. That's why the second goal was sustainable usage of components of biodiversity. That is, we are going to exploit our resources, but in a sustainable manner, without over-exploiting and ensuring that we leave behind enough resources for future generations. That balance between growth and conservation was to be struck according to the second goal of CBD convention. Growth is essential, but at the same time, environment conservation, biodiversity protection is equally important. And the only way through which we can strike a balance between growth and conservation is by promoting sustainable development. The third goal was to promote fair and equitable sharing of the benefits that arise out of this exploitation of biodiversity resources and traditional knowledge. What do you mean by this? It means whatever economic benefits we get, whatever social benefits we get from exploiting resources, this has to be fairly and equitably distributed to all the sections of the society. Just the industry, the government, and the rich cannot benefit themselves. The poor people, the local communities, indigenous, tribal communities, they should benefit because essentially they are the owners of these resources. Now, let's say in a forest area, forest resources have to be exploited. The exploitation should be done in such a manner that it should not just benefit the industry, the government, etc. It should benefit the local forest dwelling communities. This is their home, this is their habitat, this is where they reside. Their livelihood, their well-being is dependent on the forests and the biodiversity around them. So if the government and the industry are exploiting biodiversity resources, whatever benefit comes from that should be distributed, should be fairly and equitably distributed to all the sections of the society. These indigenous communities, they even own traditional knowledge. Indigenous communities, tribal communities, they hold a lot of traditional knowledge on how forest resources, biodiversity resources can be used. For example, medical application of forest resources, which is well known to tribal communities, not just in India, but around the world. Look at the application of basic resources like turmeric, neem, etc. Since ancient times in the Indian civilization, right, the traditional indigenous communities, they knew the application of turmeric and neem, the important role it could play as a antibacterial, antifungal applicant. This is traditional knowledge. Now, tomorrow, if some biotech company or pharmaceutical company comes in and takes over this traditional knowledge and commercializes it and gets a patent over it, then the indigenous communities will lose out. They won't be able to use their traditional knowledge. It affects their well-being and they'll not even get any benefit from that commercial exploitation. So to prevent such unfair patents, to prevent any monopolies and any commercialization of traditional knowledge, this provision was added. That governments have to ensure that whatever traditional knowledge and biodiversity resources that are used, the benefits should be channeled towards the weaker sections, the tribal communities and indigenous communities. There should be fair and equitable distribution of the benefits arising from biodiversity exploitation. These were the three goals laid down by the CBD Convention. And to fulfill this obligation, India enacted the Biological Diversity Act of 2002. Is that clear? 10 years later, in 2002, under the Vajpayee government, this law was enacted by the Indian Parliament. So to fulfill those three goals, three institutions were set up in India under this law. A three-tier structure was created through the Biodiversity Act. Please make a note of this. It's very, very important. The Biodiversity Act established the National Biodiversity Authority at the national level to conserve and protect our biodiversity. Similarly, at the state level, state biodiversity boards were created. And at the local level, at the grassroots, at the level of Panchayati Raj institutions, biodiversity management committees were set up. So this constitutes the three-tiered architecture in India with regard to conservation and protection of our biodiversity. Is that clear? The National Biodiversity Authority, which is headed by a chairperson appointed by the Government of India. It also consists of several members who are appointed by the government. This authority is responsible for advising the government on how to conserve and protect our biodiversity. It also raises objections on any patents that are filed which could breach traditional knowledge of India's indigenous communities. This is the primary role of National Biodiversity Authority. It advises the government on biodiversity conservation. It gives technical inputs on what measures have to be taken to protect and conserve our biodiversity, how to promote sustainable development, and how to ensure fair and equitable access to the benefits arising out of biodiversity exploitation. These recommendations, this advice is given by the National Biodiversity Authority to the central government. It also raises objections to any patent applications that are filed by companies around the world, which could breach the traditional knowledge of India's indigenous communities. That is the primary role of NBA. At the state level, the State Biodiversity Board performs a similar function. It documents all the biological resources, the biodiversity resources. It works with the national and the local bodies, coordinates with them to conserve our biodiversity. And at the bottom, that is at the grassroots, at the level of local bodies, the biodiversity management committees, they document all the traditional knowledge and the resources present in the People's Biodiversity Register. This is like a database. It's a register that is maintained at the level of local bodies, and biodiversity management committees, which has representation from local people and local officials, they update the register and document all the traditional knowledge in that region. They document all the biodiversity resources present in the region. And eventually all the data is collated to form state level registers and national level register. So this was the architecture created by the Act, which enforces the law, which prevents the misuse of biodiversity resources, which also ensures that wrongful patents are challenged and legally fought in order to protect the traditional knowledge of our indigenous communities. So this covers all the essential background that you need on this topic. Is that clear? Now coming to the current development, why was this amendment needed? Who was pushing for the amendment? Who were the stakeholders pushing for the amendment? And why the amendment was necessary? And what kind of changes have taken place? So let's understand this. See, the criticism of the law was mainly from the seed sector, the companies that manufacture seeds and plant seed varieties, also from the industry, the agri industry, biotech industry, the medicine industry, the pharma industry, and from researchers and research institutions, and also from practitioners of Ayush forms of medicine. The practitioners of Ayurveda, Unani, Siddha, homeopathy, right? These are traditional alternate systems of medicine that we have. Now, to create those formulations, like let's say a Ayurvedic formulation or a Unani formulation, the practitioners, they rely on biodiversity resources. They will need the root of a plant. They will need the produce that comes out of a plant. Maybe it could be the sap of the plant, right? Or it could be the bark of a tree, right? Or it could be other biodiversity resources, which goes into the formulation of these traditional alternative medicines, which are part of the Ayush stream of medicine. So these were the stakeholders who had issues with the existing law. They pointed out that the existing law is very restrictive. It is placing a lot of obligations, including criminal charges, on those who break the law, which is hampering research and innovation. So seed companies, several industries, cosmetic industry, pharmaceutical industry, the medical industry, and the alternate systems of medicine, the Ayush practitioners, and all the Ayush companies and hospitals we have, they were opposing the Biodiversity Act because according to them, the law was very restrictive. It was limiting their access to natural resources, which in turn was affecting the research and innovation in these key sectors. It's in this context that the government has considered amending the law. That's why in 2021, the amendment bill was brought out, and after a lot of deliberation and discussion, now the Lok Sabha has passed the amendment bill. It is yet to become an act, Of course, it has to be passed by Rajya Sabha. Finally, the presidential assent has to come. But as of now, the Lok Sabha has passed the amendment bill. So please note down this point. According to the critics, they were pointing out that the previous law, that the 2002 law, which is still in force by the way, it was very restrictive according to them, which was affecting research and innovation in key sectors. It was limiting access to natural resources, which was affecting the industry. Is that clear? Even researchers from the academia, experts, they were also pointing out that they're not able to conduct research. They're not able to take forward innovation and research and development because of the restrictions, the compliance obligations placed by the Biodiversity Act. Since it involved criminal charges as well for breaching the law, it was hampering the industry and the research institutions from accessing the essential resources. Got it? See, under the CBD Convention, we have a protocol called Nagoya Protocol. The Nagoya Protocol was adopted in 2010 following the Nagoya Summit of the CBD Convention. Nagoya is a place in Japan. It's a city in Japan. That's where the CBD Summit of 2010 was held. It led to the Nagoya Protocol that provided for a mechanism to achieve the third goal of CBD Convention. What is the third goal? The third goal is to achieve fair and equitable sharing of biodiversity resources and the benefit arising out of exploitation of biodiversity resources. So to implement that third goal, Nagoya Protocol was adopted that provides access and benefit sharing mechanism. It determines how biodiversity resources will be accessed by the industry, what kind of regulations, what kind of compliance should be placed to limit the exploitative use of resources. It determined how the fair sharing mechanism can be implemented in order to benefit all the stakeholders, especially the weaker sections, the tribal communities and the indigenous communities. So under Nagoya Protocol, India also had adopted these mechanisms regarding access sharing and benefit sharing, but this apparently had become very restrictive. It had become a very strict obligation for the industry to follow. The seed manufacturers, pharmaceutical companies, research institutions, Ayush practitioners, they were all pointing out that as we are following Nagoya Protocol restrictions and trying to achieve the CBD goal, it is placing a lot of unnecessary restrictions on research and innovation, and this was hampering the advancement of these fields. So this was the concern which pushed the government to amend the law, to seek the amendment of the law. It's big. It's big enough. Sorry for the interruption. There's a small update from the operations team. Now coming back to our discussion. Now we understood why the amendment was necessary, why the government wanted an amendment to be done. It was mainly because of the pressure coming from the industry. Now let's understand the provisions. Let's compare the amendment bill with the existing Biodiversity Act. Let's understand what changes will happen once the amendment becomes an act. Let's compare the two and understand what changes are going to take place. Please note down these points. It's very, very important. First and foremost, with regard to access to biological resources, a change is being done. Under the existing law, anyone who seeks to access biological resources, which is linked with traditional knowledge, they had to obtain prior approvals from the concerned authority, which is nothing but the National Biodiversity Authority. Now, let's say there is a research institution, or let's say there is a Ayush Pharma lab. They want to access biological resources, which is linked with traditional knowledge, and they want to commercialize it. Before taking up that commercial exploitation, they have to seek permission. They have to get the approval of National Biodiversity Authority. This is the existing provision under the Act. But now the government wants to change this. A slight modification is being done. It classifies the entities and activities that require legal permission. Instead of placing this restriction on every institution, some of them will be exempted going forward. Few seed manufacturers, Ayush practitioners, and certain industries will be exempted from the need for asking permission. Without seeking permission from National Biodiversity Authority, they can go ahead and extract biodiversity resources in order to further their research and innovation. So this categorization is being made where certain industries will be exempted from the need to ask for permission, to ask for approval from the National Biodiversity Authority. Essentially, it will make access to biodiversity resources easier for the industry. Previously, it was seen as very difficult because of all the approval and licensing mechanism. Now, since this will be diluted, it will become easier for certain select industries to have easy and direct access to biodiversity resources. Next, with regard to IP rights, intellectual property rights. Under the current law, if a company is applying for a patent with regard to biodiversity resources, which is linked with traditional knowledge, first they had to get the approval of National Biodiversity Authority. Even before applying, even before a company could apply for the patent, apply for IP rights, it had to first seek the approval of NBA. NBA would check whether this patent application, will it violate any rights of traditional knowledge, the rights of traditional communities. If there are any such violations happening, then NBA would not grant the permission to even apply for the intellectual property rights. So this was again seen as restrictive, which was hampering research and innovation. Because without intellectual property rights, without according patent rights, companies will not be interested to invest a lot of money into research and innovation. So the amendment seeks to simplify this. The amendment will remove this requirement, and the permission will have to be sought during the grant process of the patent, not while applying. Previously, companies had to apply. When they are applying for the patent itself, they had to seek permission. Right now, the change is that companies are free to apply. They can go ahead and apply for the patent. But when the IP rights are being granted, when it's about to be approved by the Patents Office, that is when NBA permission is needed. That is when companies have to approach NBA that we are filing this patent regarding biodiversity resources and traditional knowledge. Please check if there are any violation of rights and then guide us accordingly. So companies get a extension here. Instead of seeking NBA's permission while applying for patent, they can delay this. They can apply for the patent first. When patent is being granted, that is when they have to seek permission from NBA. This will simplify the norms, the regulations for the industry, and it will promote research and innovation according to the government. Next, exemptions are being given by the government to the Ayush industry to promote traditional alternative medicines, to promote Ayurveda, Unani, Siddha, and homeopathy. Exemptions are being given specifically to Ayush practitioners and Ayush companies. So those companies producing Ayush drugs and Ayush practitioners, they need not seek any permission or approval from National Biodiversity Authority to use biodiversity resources. If they're using it to formulate medicines, Ayush medicines, they need not seek permissions, and this exemption has been proposed by the government. Next, benefit sharing. To share the benefits fairly and equitably. Previously, the NBA would determine the terms of benefit sharing, how the benefits will be shared with traditional communities and the companies which are commercializing the traditional knowledge and the biodiversity resources. So clearly, the monetary division and the non-monetary sharing of benefits would be determined by the NBA under the existing act. But going forward, this applicability is being removed. For research, for conducting a bio-survey, and for bio-utilization, this requirement of benefit sharing is being removed by the amendment. Is that clear? The government says even this is necessary to promote research. But this is where criticism comes in. Critics are pointing out all these exemptions being provided will simply provide industry an opportunity to overexploit our resources. It will allow the industry to even exploit traditional knowledge without sharing the benefit of that with the tribal communities and indigenous communities. So these concerns are coming up. Even with regard to criminal provisions, the current act in the current form, it imposes criminal penalties for violation of the act. If let's say there is a company which has not taken NBA's approval, it has not given NBA notice while applying for IP rights, or if it has not allowed benefit sharing to happen, if any such violations are done by a company or by an individual, they attract criminal charges under the current law, which includes a jail term and a hefty penalty. Now this is being removed. It's being decriminalized. The amendment decriminalizes the violation of the law and only provides for penalties. It only provides for imposition of fines through the National Biodiversity Authority and the National Green Tribunal. They will only have the powers to impose fines, but criminal charges cannot be pressed for the violation of the law. The government says this is necessary to promote ease of doing business, to promote industry, to do business, because criminalization was a hurdle. If criminal charges are possible, investors and researchers will be concerned, worried, and they will never take the step to promote research and innovation. That's what the government says. But critics are upset. Critics are pointing out, if you don't have criminal penalties, then there will be no deterrence. There will be nothing to scare the industry, which might overexploit and harm the biodiversity and as well as the traditional communities. So these are the changes which have been proposed by the government through the amendment bill. But environmental activists are criticizing the amendment bill and they're challenging it. Is that clear? That is the final conclusion. The government has said that the amendment ensures that tribes and vulnerable communities benefit from the proceeds of traditional knowledge, its exploitation, and medicinal forest products. By decriminalizing certain activities, it will encourage the industry, particularly Ayush and Ayurveda, and it will promote ease of doing business, thus promoting research and innovation. So the government says that there is a justification for the simplification of the rules and the removal of these restrictions and criminal penalties. But environmental activists, NGOs, civil society, and organizations, they are concerned about biopiracy. They are worried that now the industry will take over traditional knowledge. They will get patents on traditional knowledge because they don't have to go through any approval process. They don't have to share the benefits as well in the name of research and innovation. Because of the exemptions being proposed, the fear is that the industry will now take over traditional knowledge from tribal communities and they will not even compensate them. That is a case of biopiracy, where biological knowledge, bioinformation, traditional knowledge is stolen by research companies, pharma industry, seed industry, and they commercialize it and they establish a monopoly over it. So this is the concern of the environmental organizations and various NGOs and civil society organizations. They're also worried that this will destroy biodiversity, as it allows the industry a free hand to access biodiversity resources. They fear that it will lead to destruction of our biodiversity as well, thus defeating the very goal of the law and as well as defeating our commitment to the CBD convention. Is that clear? So it's a debatable topic, but the government feels that it is justified. It is necessary to enable the industry to promote ease of doing business and to promote the culture of research and development. Is that clear? So this is what you should know about the Biological Diversity Amendment Bill of 2021, along with the entire background. All the key facts and concepts that I have discussed, they're all important for your prelims, and the analysis that we carried out, the arguments in favor and the arguments against, Both are important for your mains examination. So now let's take up a practice question. Please read the question carefully. I will launch the poll as well. Let's make it interactive so that you guys can also try and answer the question. Consider the following statements. The National Biodiversity Authority is a statutory authority. It functions as an autonomous body under the Ministry of Environment, Forest and Climate Change. The NBA takes necessary measures to oppose the grant of intellectual property rights in any country outside India on any biological resource obtained from India or knowledge associated with such biological resources derived from India illegally. How many of these statements are correct? Let's launch the poll. I'll give you 30 seconds. The poll is live. Go ahead, read the question again if you want, think what we have discussed, and then give the answer. Directly or indirectly, I've already mentioned all the points. Let's see how many of you can get it right. 15 seconds to go. All of you, please attempt the question. Please ensure you try and give the answer. 5 seconds to go. Okay. 47% have said option B. But you guys are wrong. Majority of them have given the wrong answer. Only 38% got the right answer. The correct answer is option C. All the three statements are correct. Let me explain. National Biodiversity Authority is a statutory authority. Obviously correct. What do you mean by statutory authority? It means it has been established through a law. If a body has legal backing, if it has been established through a law passed by the parliament, such a body, such an authority is called a statutory authority. Obviously, NBA is established through Biological Diversity Act. So it's a statutory authority. It is an autonomous body under the Ministry of Environment. It functions under Ministry of Environment, Forest and Climate Change, and it's an autonomous body. Is that clear? Which means its functioning is more independent from the ministry. The third statement is also correct. In order to protect India's traditional knowledge, to protect our biodiversity resources, and ensure that our indigenous communities get the benefit from exploitation of traditional knowledge, NBA opposes the patent application anywhere in the world if it is a violation of our traditional rights and if biodiversity resources are being exploited from India illegally. Essentially, NBA acts against biopiracy. The examples I gave you, turmeric, neem, basmati rice, all these were being patented by Western companies. They wanted a patent on turmeric and its antiseptic properties. This is something which was known to Indians from centuries, from our ancient civilization days. The antibacterial, antifungal properties of neem was being patented. The unique properties of basmati rice was being patented by foreign companies. Every time NBA fought this, India fought a legal battle to ensure that biopiracy was prevented and our traditional rights and the rights of our indigenous communities was protected. We defeated all the patents. That is why today turmeric, neem or basmati rice, they are not under intellectual property rights. So NBA opposes the grant of IP rights if it is violating our traditional rights and if the material is being illegally sourced from India. So all three statements are correct. Option C is the right answer. Now let's see if you guys have any questions, any doubts. Please bring it up. I'll try to answer as many as possible. SMEs, please push the questions into dismiss section. Ekta is asking, sir, should we learn all the sections and rules of the Act? Not all the sections and rules. The ones I have pointed out, they are important. Understand the objective of Biodiversity Act and also understand the changes which are being proposed to the amendment bill. Right? There are 4 or 5 points I brought up. If you remember that, that is more than enough. Bharat is asking, sir, this easy access being given to corporates may be misused and exploitation of natural resources may happen. Yes, you're absolutely right. That is the concern raised by environmental groups. They're saying that if you're giving such easy access to the industry, it might lead to over exploitation. It might damage our biodiversity. That is the biggest criticism. Partha is asking, sir, differences between the act and the amendment is not clear. Please explain in short. Let me give you a brief summary. Under the previous act, under the existing act, which is in force even today, right? The Biodiversity Act of 2002, the industry had to seek approval from NBA before exploiting biodiversity resources. Is that clear? The industry had to seek NBA's approval before even applying for a patent. And if it gets a patent, any benefits that come out of it, monetary benefit, non-monetary benefit, that had to be shared equitably with the traditional communities. That sharing mechanism would be determined by NBA. These were all restrictions on the industry. Now all the restrictions are being removed. These restrictions are being removed through the amendment. So going forward, Ayush practitioners, pharmaceutical firms, seed manufacturers, etc., they can go ahead and access biodiversity resources without approval from NBA if it is for research purposes only. By saying that they are researching on a new drug, they can gain access to biodiversity resources without even asking NBA for approval. So NBA loses its regulatory control. They can apply for a patent without NBA's approval. They have to ask NBA's approval only when IP right is being granted, not while applying. And the benefits that come out of it, if it's coming out of research from the industry, they need not share the benefits. They need not share the benefits with the traditional communities, thereby allowing the industry to make more profits. The government says it is necessary to promote research and innovation, and the government says we still have enough powers to distribute the benefits to help the tribal communities and indigenous communities as well. But critics are pointing out there is no clarity on how benefit sharing will be provided, and they believe that industry will benefit at the cost of our traditional communities. All right, so that is the summary. Pulkit says, sir, seeing the Biodiversity Amendment Act and Forest Conservation Act, which is also being amended, can it be concluded that the government is giving higher priority to economy over environment? You're absolutely right, Pulkit. That is the criticism that environmental groups are raising. See, two important environmental laws are being amended by the Modi government. One is the Forest Conservation Act, which you would have studied in previous sessions, and the Biodiversity Act. Critics are saying that these amendments will only benefit the industry. It means the government is prioritizing economic growth over environment conservation. Is that clear? But the government is saying it is necessary to promote industrial growth while protecting our environment. This is always a dispute. The dispute between growth and conservation. Both are conflicting objectives. That is why a government should promote sustainable development. We should have enough laws, regulations to strike the balance between growth and conservation. You can't compromise either of them. Economic growth is necessary. At the same time, conserving your environment and biodiversity is also equally important. Is that clear? So it appears that, according to critics, that the government is prioritizing growth over conservation. Ashwin is asking, sir, NBA is under UNCBD. No, NBA is under the Biological Diversity Act. NBA is an Indian authority. It has nothing to, it is not directly under UNCBD. It's under the Ministry of Environment and Forest. Banu is asking, what does biosurvey mean? Biosurvey is an exploration exercise. The seed industry, pharmaceutical industry, cosmetic industry, when they are developing new products, they carry out an exploration, a scouting exercise. They look at what resources are available in our forests, in our nature, which can be used in their products. That exploration exercise is called a biosurvey. They survey the biological resources which can be used in the industry. Right? from our forests, from our ecosystems, lot of material, lot of forest produce can be used in the industry. So to figure out which of them can be used, the industry conducts these researches, right? It's an exploration exercise, which is called a biosurvey. All right, these are the questions. Now let's move on to the second topic, the National Coal Index. It's a very small topic, but very important for your prelims. The National Coal Index was in news because it was recently published by the Ministry of Coal. The Ministry of Coal published the National Coal Index for the month of May 2023. And according to this index, the index has fallen by a very significant margin. It has fallen by 33.8% on a year-on-year basis to 157.7 points. Please look at the graph that I've shared here. I've taken this directly from the Ministry of Coal's website. It shows the decline in National Coal Index of Indian coal. Last year, in May 2022, the coal index was 238.3. In 1 year, it has fallen to 157.7 points, which is a 33.8% reduction. Now, this reduction is actually good news for the coal industry in India. Is that clear? Because it signifies a reduction and stabilization of coal prices in the country. And please understand that prices will stabilize only when your demand supply situation is matched. If there is a mismatch in demand supply, prices will not be stable. Right? That is lesson 101 in your economics. Demand supply equation, how it determines prices, is a basic lesson. If demand is high, supply is low, prices will shoot up. And the opposite will happen. If supply is more and demand is less, prices will drop. But to provide stability in any commodity, demand and supply should be very well matched in the economy. That is when your prices will remain stable. According to the index, this fall in the index is good because it indicates a drop in coal prices and a stabilization of coal prices because there is a strong supply of coal in the market. There is enough stockpile available with the factories and industries, and the ministry, Coal India Limited, the government, they've all done a good job to ensure that the supply is brought up to match the demand, thereby securing energy security for the country. I hope you know that coal is critical, a critical fossil fuel based energy for our country. Even today, majority of our electricity, almost 59% of our electricity is generated through thermal power plants, which all make use of coal, right? They make use of a type of coal called non-coking coal. This is the type of coal used in thermal plants to generate steam, which generates electricity. The other kind of coal, coking coal, which is used in metallurgical industry to turn iron into steel. Even this is critical for our metal industry, which has an impact on construction and other industries as well. According to this index, the index has dropped in both the categories. Non-coking coal price and coking coal price both have dropped, which is positive news for the Indian economy. The index for non-coking coal has dropped from 224.65 to 147.5 points in comparison to the last year. The index for coking coal, which is crucial for steel production, also has fallen significantly, thus indicating a stable coal supply and sufficient stockpile of coal, which is matching the demand, thereby securing the country's energy security. Is that clear? This is what you learn from this index. What is the takeaway from here? The takeaway is that there is abundant coal availability in the Indian market if the index drops. If the index increases, it means there is a demand-supply mismatch. It means the prices have shot up because demand has gone up but supply has not been matched. So please remember this analysis. In prelims, there might be a question. You might get a factual question on National Coal Index. I'll give you some basic facts, and there could be an analysis based question. UPSC might ask, if National Coal Index has increased, what do you infer from this? The inference is that if the index is increasing, it means prices have gone up. It means demand supply is not being matched. Supply has been affected and demand has shot up. That is the inference you draw from it. And the opposite, if the index declines, like the index of May 2023, which has seen a very big decline, it shows that prices have reduced and stabilized, which indicates a balance in the demand supply equation, and it means that there is enough coal stockpile in our country. Is that clear? So please note down, it is a price index. It is essentially a price index that combines coal prices from all the sales channels. 3 sales channels are accounted: the notified prices by the government, the auction prices, and import prices, because we import coal as well along with domestic production. So all the 3 prices are accounted to create this price index. All right, this is one important fact. This index was conceptualized and developed by the Indian Statistical Institute based out of Kolkata. It's the ISI of Kolkata which developed and conceptualized this index to measure the trends in coal prices. It essentially measures the trends in coal prices and helps us understand the availability of coal in the Indian market. All right? It reflects the change in price level in a particular month relative to a given base year. And the base year chosen is 2017-18. All right? The index was released in 2020, in June 2020. So the base year used in the index is 2017-2018. So the prices in a given month is compared with prices in the base year. That is the price index. It helps you determine the fluctuation in coal prices and the situation in the coal market, whether demand supply is being matched. So it's a very reliable indicator to understand the market dynamics and any fluctuation, adverse fluctuation in coal prices. Is that clear? So now, based on the latest index from May 2023, we can deduce that there is substantial coal stockpile in the country because there is a stable supply ensured by the Ministry of Coal, Coal India Limited, and also by the government. So this guarantees our energy security. It shows that our supply demand equation has been aligned and it creates resilience in the industry. Many industries can plan accordingly. Metallurgical industry, construction industry, right? Thermal power plants, they can all plan accordingly because their requirements can be met as there is sufficient coal stockpile in the country. So that is the inference we draw from the trend. So based on this, a very conceptual question can be asked by UPSC. Is that clear? Now please take a look at the question. Which of the following statement is incorrect with regard to National Coal Index? Please read the question carefully. It's a price index used to understand coal supplies needed for energy security. It's part of Index of Industrial Production. It's released by Ministry of Coal every month. It's composed of a set of sub-indices for non-coking coal and coking coal. I'm launching the poll. I think 15 seconds is enough. It's a small question. Let's see how many of you get it right. I want all of you to answer. I want all the students to attempt the question. Such simple questions can be asked by UPSC. Be prepared for it. 54% have got the wrong answer. Why? I told you that the index is released by Ministry of Coal. It is released every month. Is that clear? It is released every month by the Ministry of Coal. Actually, C is correct. It's not incorrect. The question is asking you to identify incorrect statement. A is also correct. It's a price index to determine coal supplies to understand the energy security situation. Third one is correct. It's released by Coal Ministry every month. Fourth one is also correct. It's composed of set of sub-indices that measures prices of non-coking coal and coking coal. The incorrect statement here is option B. It is not part of Index of Industrial Production. IIP is a different index altogether, measuring industrial growth in the 8 core industries. It's brought out by the Central Statistical Organization. That's a different index altogether to measure industrial growth in the 8 core industries, including coal. But National Coal Index is different. It's measuring the price variation which is happening. It's brought out by the Coal Ministry every month. All right. So B is the correct answer. It is not part of Index of Industrial Production. Now, let's move on to the next topic from polity. Rule number 267 of the Rajya Sabha. This topic was in news because the opposition parties in the parliament, they have been demanding the government to hold a detailed discussion on the Manipur situation. As you know, Manipur has been burning for almost 3 months right now. The government's actions have been criticized heavily by the public, the media, and the opposition. And the opposition has been pushing the Modi government to hold a detailed discussion on the issue because the legislature has the constitutional authority to hold the executive accountable on the floor of the house. Correct? The executive is answerable to the parliament, not just to Lok Sabha, even to Rajya Sabha. So if the opposition is pushing for a certain discussion, the government ideally should oblige. If the required norms and the rules are being followed, the opposition demand answers from the government on the Manipur situation should be met by the government. Opposition parties have insisted for a discussion in Rajya Sabha under rule number 267 of the Rajya Sabha. But government has not agreed to it. The government has said we are ready for a short duration discussion under rule 176 of Rajya Sabha. But the government is not agreeing to a debate under rule 267. So let's understand what is rule number 267. Why opposition parties are insisting for a discussion under this rule and not under rule 167. Let's understand this thoroughly. See, the parliament, be it Lok Sabha or Rajya Sabha, they conduct their business according to a set of rules and procedures that have been laid down. For Lok Sabha, there is a set of rules and procedures guiding its conduct of business. Similarly, for Rajya Sabha as well, there is a set of rules and procedures that guides the conduct of the house. Understood? So elected representatives who are part of the ruling party, who are part of the executive, they are answerable. They are answerable to the MPs, to the other elected representatives, to the opposition on the floor of the house. So in the Rajya Sabha, you have the rules of procedure and conduct of business in the Council of States, which is the upper house, which came into effect in 1964. Just like Lok Sabha has a set of rules and procedures guiding its conduct, guiding its business. Similarly, even for Council of States, there is a set of rules and procedures that was introduced in 1964. These rules and these procedures of the House, they determine how MPs can question the minister, how they can question the government, how they can push for debates and discussions on crucial issues. All those procedures are defined. Even the procedure regarding tabling of a bill, how discussion will happen on a bill, how voting will take place on a bill, what will happen with regard to a hung vote, what will happen to the powers of the chairman, the chairperson of the House. All such norms are laid out under the rules and procedure of the conduct of the House. Now, MPs who want to ask questions in the Rajya Sabha, they have to first inform the chairperson, that is the Vice President of India. I hope you know that Vice President of India is the ex officio chairman of Rajya Sabha. That is, by virtue of being the Vice President of the country, he or she automatically becomes the chairman of the Rajya Sabha as well. So if an MP has to raise questions, if an MP has to push for a debate and ask answers from the ministers and the government, they first have to inform the presiding officer. Usually it's the chairman of the Rajya Sabha. This prior notice, prior information which is given by the MP regarding his intention to ask a question is called a notice. Now let's say opposition leader wants to question the government. So he first has to intimate the chairman, the presiding officer. This prior information regarding an upcoming question or a debate is called the notice. This notice will be considered by the chairman. The notice should be passed to the Secretary General, right, who manages the conduct of business in the House. The Secretary General will pass the notice to the chairman. Now the chairman will consider this based on other concerned rules and procedures and decides to admit or dismiss the request. The chairman, the presiding officer, will look at the other rules and procedures, and based on that will determine whether this notice should be admitted or dismissed. Is that clear? So there are many parliamentary tools through which the elected representatives, the MPs, can hold the executive accountable. For example, we have starred and unstarred questions that can be raised to seek answers from the concerned ministers. Now, before a starred and or unstarred question can be brought up, a 15-day notice has to be given. MP who wants to ask that question, he or she has to inform the Secretary General and the presiding officer 15 days prior that they are looking to raise a starred or unstarred question, so that the presiding officer can pass on the question to the concerned minister and give them enough time to respond. This rule, this procedure is laid down in the conduct of business for Rajya Sabha. Similarly, 3-day notice should be given for half an hour discussion. It's another parliamentary tool. MPs can push for a half an hour discussion on a key topic. For that, a 3-day prior notice has to be given, right? So these are different parliamentary procedures that we have. And under the code of conduct of Rajya Sabha, the rules and procedures of Rajya Sabha, there is one very important rule, that is rule number 267. Under this rule, any member, any MP can push for a debate on a matter of urgent public importance. And if this rule is accepted, if this notice or this motion, if it is accepted by the presiding officer, then every other rule, every other business in the House will be suspended for the entire day. Is that clear? If a motion under Rule 267 is accepted by the presiding officer, then all the business of the day, every other rule in the House will be suspended, allowing for a detailed discussion on this topic of urgent public importance. That is why Rule 267 is quite powerful to hold the government accountable. Right? MPs can push for a debate under Rule 267, which means every other business has to be suspended. Every other rule which is in operation will be suspended. All right? The government can't bring any bill or take up any other matter for discussion. Throughout that day, the only issue which will be discussed is this issue which the MPs are trying to bring up. This matter of urgent public importance will be discussed throughout the day, and the government will be answerable for all the questions that are raised in the House. So it's a very important, powerful tool available to Rajya Sabha MPs. Is that clear? The condition is that the MP must give a notice before 10 a.m. on that day. That is the condition. The prior notice should be given before 10 a.m. of the day to the Secretary General, seeking a suspension of business for the entire day in order to raise an urgent matter of public importance. The Secretary General will pass on this notice to the chairman, to the presiding officer of the House. And if the chairman admits the motion, then all the rules and conduct of business will be suspended for the day. Is that clear? The chairman can dismiss this as well. The chairman is not obliged. If there are other key matters being discussed, if the government is not supportive, the chairman has the right to dismiss the motion under Rule 267. He need not admit the discussion to happen. But if the motion is admitted, then the motion is put to vote, and if majority support comes in, which means government also has to support this, it means that all other business for the day will be suspended. No other business will be taken up. No other matter will be discussed except for this one issue of urgent public importance. Opposition MPs feel that the Manipur issue is so critical for the country's stability and security and the well-being of people of Manipur that the issue deserves a full discussion under Rule 267. But the Modi government is not inclined to support it. Modi government has said, we are ready for a short duration discussion. We are ready for a short duration discussion which will take place for 2.5 hours under Rule 176 of Rajya Sabha. But opposition MPs are not happy with this. They have rejected this offer from the government. They have said, we want a full day discussion only under Rule 267, not under 176. They are not agreeing for a short duration discussion. Is that clear? That is why it's become a controversy between the opposition and the ruling party. In the past, there have been many instances where Rule 267 of Rajya Sabha has been invoked. It's not the first time. At least there are 11 instances since 1990 where this rule has been invoked to suspend all business in Rajya Sabha and all the rules in Rajya Sabha to allow for a full day debate on a particular issue of national importance. For example, on the Gulf War, on the corruption scandals in 1990s, this rule was invoked where the government agreed for a full day discussion. Under various chairmans on key issues like demonetization and other important issues, at least 11 times the chairperson has admitted the motion allowing for a full day discussion in the Rajya Sabha on key issues of national importance. Is that clear? So there is a precedent. It has happened many times before. At least 11 such discussions have taken place since 1990. So please understand how this rule is different from Rule 176. That is where UPSC might focus upon. Rule 267 will suspend all the business for the day. If the notice is given before 10 a.m. and admitted by the chairman, all business and all rules will be suspended, allowing for a full-fledged debate on the issue. All right, the chairman will even set a time limit for speeches if required, but there is no voting. There is no formal motion which is moved against the government, or there is no voting which takes place. It's not a censure motion. Rajya Sabha cannot censure the government. It's not a censure motion which has any impact on the government. All right, there's no voting, there's no formal motion which is moved. It only pushes the government to give answers to the elected representatives and to the public in general. Rule 176, on the other hand, provides for short duration discussion of 2.5 hours, which the chairman will decide along with the leader of the house, the leader of the council. If Rule 176 is moved by an MP for a short duration discussion, which is being currently pushed by the government, the chairman, if he admits this, he will consult with the leader of the house, that is the leader of the council of states, and they will determine a date, and they'll set a time as well, a time of 2.5 hours to discuss that issue. But it's only a short duration discussion. So opposition leaders are not happy with it. They consider Manipur issue to be of great national importance, correctly so, and they're pushing the government for a discussion under 267. Is that clear? So please understand these nitty-gritties involved in parliamentary procedures. It's very, very important for your prelims. Now look at this question. Consider the following with regard to Rule 267 of Rajya Sabha. 3 statements have been given. Let's see how many of them are correct. Let's see how many of you can get it right. First statement says Rule 267 of Rajya Sabha is the same as adjournment motion in Lok Sabha. In the year 2000, Rule 267 was amended based on recommendations of the Committee on Rules to include that a motion on an important matter could be considered only if it was mentioned in the listed business on a particular day. Voting on discussion under Rule 267 could lead to the resignation of the concerned minister. I'm starting the poll. It's a big question. I'll give you 30 seconds. Let's see how many of you get it right. This will test your understanding of polity-related topics. Please go ahead, give your answers. 20 seconds to go. Is it similar to adjournment motion? Was this amendment done in 2000? Will it have any impact on the government and the minister? Right? I will give you the explanation. Don't worry. Last second. 38% have said option B. This is wrong. Only 28% of them have got the right answer. Option A is the correct answer. One only. There's only one correct statement here. The correct statement is statement number 2. Statement 1 and 3 both are wrong. Both are incorrect. I told you it's not a censure motion. It has no impact on the government. It will not lead to resignation of concerned minister. In fact, there will not be any voting. No formal motion will be moved. It's only a discussion motion. So statement 3 is wrong. Statement 1 is wrong because it's not the same as adjournment motion in the Lok Sabha. Please read about this. I'll give you some basic points, but read about adjournment motion in Lok Sabha. It's slightly different. Adjournment motion will also lead to adjournment of all the other business in order to discuss a pressing matter which is pushed by the MPs. But this has to be supported by 50 MPs in the House. Whereas under Rule 267, 1 MP is enough to push for a discussion. Is that clear? For adjournment motion, support of 50 MPs is needed. Only then the Speaker of Lok Sabha will consider the request. That's not the case under Rule 267. All right? And adjournment motion, right? Even though it also brings up issues of national importance, the procedure is different. Adjournment motion is available only in Lok Sabha, like Rule 267 is available only in Rajya Sabha. Even though the end objective is pretty much the same, the processes are different. So it's not the same. So 1 and 3 are wrong. Statement 2 is correct. In 2000, Rule 267 was amended. That's why the notice has to be given before 10 a.m. by the MP, which means the matter to be discussed should be listed in the business of the particular day. Only if the notice has been given before 10 a.m. will the matter be listed. And if the motion is accepted, then all other businesses are suspended by the chairman, allowing for a full day discussion on this issue. So statement 2 is correct. So option A, only one statement is correct. Now moving on. 4th topic, Jan Vishwas Bill. Another important bill that had come up in the parliament in the Lok Sabha. The reason why it's in news is because the Jan Vishwas Amendment of Provisions Bill 2023 was passed by the Lok Sabha during the ongoing monsoon session. So let's quickly understand what this bill is all about. It's very simple and straightforward. There are some key points I'll highlight. It's very factual, in fact, but it could be relevant for your prelims. The Jan Vishwas Amendment of Provisions Bill 2023. This bill, as the name itself tells you, it seeks to build Vishwas or trust. The objective of the bill is to build trust with the people, with businesses, with industry. Is that clear? It seeks to promote the trust of the people on the regulatory framework, the legal framework in the country, especially with regard to conduct of business. It redefines the regulatory landscape in India. All right. And the primary objective is to decriminalize several minor offenses in 42 different legislations. Let me explain this in very simple words. See, we have around 42 laws that applies for various sectors of the economy, various industries, and some of them contain criminal provisions. Like, for example, under Drugs and Cosmetics Act that regulates the pharma industry, cosmetic industry, there is a provision that if substandard drugs are produced by a company, then the concerned individuals will attract criminal provisions. That is, they can be arrested, thrown into jail, along with hefty penalties. I'll give you one more example. Under Environment Protection Act, to prevent pollution, to protect our environment, we have this law, the Environment Protection Act, which provides for polluter pays principle. That is, the industry causing pollution should pay for the damages. And under the act, there is a criminal provision as well. If, let's say, from a factory, toxic chemicals have leaked due to negligence, in such a case, the factory owners can be arrested under criminal provisions. Is that clear? There are many such laws in India that provide for criminal penalties for violation of the laws. There are 42 such acts. Now, the government is looking to decriminalize all of them in order to promote ease of living for the people, for the common man, and to promote ease of doing business in the country. Now, if for every act, if there is a criminal provision and arrest possibility, people will be scared. You can't trust the government. Tomorrow you'll be worried that you might breach a law and you might get arrested. Imagine investors, factory owners, industries, they will always have that fear, especially MSME industry, which is the backbone of our economy. Before taking up any activity, they have to think about hundreds of regulations, hundreds of laws, because they always have a fear. They are worried that if they breach any law, they could be arrested and jailed. They could face criminal charges and criminal penalties. That breaks the trust between the government and the people, government and the industry. It makes life difficult. It makes doing business difficult. So to simplify this, the Modi government is introducing this reform. It's a major change in the regulatory landscape, which will decriminalize several minor offenses under a total of 42 separate laws. Instead of amending every law separately, through one bill, all the laws are getting amended. That is the purpose of Jan Vishwas bill. Is that clear? Instead of amending 42 laws separately, which is time consuming, which is a redundant exercise, through one bill, all those laws will stand amended. Essentially, the criminal provisions will be removed. Is that clear? All these criminal provisions will be decriminalized. Instead of jail, they will only face fines. For violation of these laws, the one who has broken the law will only be penalized. They'll only have to pay a fine. They will not be arrested. They'll not be jailed. They'll not face criminal prosecution. They'll only be penalized through fines. This is the big change which will happen, and it has been tabled by the Commerce and Industry Ministry last year in December 2022. It went through a lot of discussion within a joint parliamentary committee, because see, these provisions can be controversial as well. What if the government is making it too easy for the industry? What if important provisions are being removed and industry is allowed to bring substandard goods, pollute the environment, and they'll not face any charges, any deterrence? There is a concern here. So because of the concern and criticism, the bill went through a lot of discussion through a joint parliamentary committee, and finally the bill has been brought out and it has been passed in the Lok Sabha. Is that clear? Now, let's see what the bill proposes. The bill is decriminalizing 180 offenses across 48 different laws. It's going to replace imprisonment. It's going to completely remove the jail provision in these 180 offenses under 42 acts. And this will be replaced with a system of fines. These fines will compound. That is, for every offense, the fines will increase. The government feels that this is a deterrent. This is enough. Instead of jailing the people who are accused of these violations, government believes it's a better practice to levy heavy fines on them. And for every repeat offense, the fine will compound, meaning the fines are going to increase for repeat offenses. So the government feels that this is a deterrence. This is enough to deter the industry, to deter people from committing violations of these laws. Penalties under various laws like Indian Post Office Act, Drugs and Cosmetics Act, Environmental Pollution Act, all these criminal provisions are being removed. And a grievance redressal mechanism will also be set up to determine the penalties and to resolve the disputes. From concerned ministries, an adjudicating officer will be appointed who will determine the fine to be levied as a penalty. Is that clear? For all the 42 laws, under each concerned ministry, there will be an adjudicating officer. This officer will determine the penalties, and these penalties will compound with repeat offenses and over a period of time. And the fines will also increase at a rate of 10% every 3 years. The fines will not be constant. It will keep increasing by 10%. There will be a periodic revision every 3 years to ensure that the fines are high enough to act as a deterrent against violation of the law. Is that clear? The government says such a law is needed to support the MSME industry, because right now the industry is worried about invoking criminal charges. They're worried about getting jailed for any small violations. There are several laws in India which is placing a strict compliance on the industry, and this is affecting the ease of doing business. Ease of doing business is getting affected. So that is why the government has tried to decriminalize these provisions through the Jan Vishwas Bill. Is that clear? The government feels that by decriminalizing the provisions, it will build trust with the people and the industry. It will make life easier for investors, for owners of factories and industries. It will make business easier. It will make the conduct of business easier, especially for the MSME sector. All right? It reduces the compliance burden. They need not worry too much about regulatory compliances, getting licenses and approvals every time. According to the government, it has become a hurdle to do business in India. Investment decisions have been affected. So by decriminalizing them, we can accelerate investments. We can bring more investments into MSME sector and drive more economic activity. It also reduces the judicial burden. Now imagine if thousands of cases are filed every year under these 42 laws, which involves criminal charges. All the cases will add to the judicial burden. We already have a huge backlog of cases in our judiciary, right? So since we are decriminalizing the provisions, the penalties will be decided by the adjudicating officer, who's a government officer. The cases will never reach the court. For dispute resolution, there is a grievance redressal mechanism. So it will reduce the judicial burden, and the government feels it will create trust-based governance. It will build trust between government and the industry and government and the people. That's why it's named as the Jan Vishwas Bill. All right? But however, there is a strong criticism here. Critics are pointing out that if you're decriminalizing so many provisions, if you're carrying out a blanket removal of the jail provision, the imprisonment provision, then there will be no deterrence for the violators, especially in case of serious offenses. The example I gave you under Drugs and Cosmetics Act, if a pharma company has produced substandard drugs, the owners will go to jail under the current law. But right now, government is amending it, removing the jail provision and imposing only fines and penalties. Critics are pointing out this is not sufficient to deter them from making those mistakes. Those mistakes can cost lives. Tomorrow, if there is a toxic industry that has polluted the environment, instead of putting them in jail, right, they'll only be penalized. Big factories, industries can afford to pay the fine and continue polluting. They will have no deterrence. There will be no legal deterrence that will prevent them from breaking the law. This is a valid criticism brought up by the critics. They're also saying that it's a quasi decriminalization. The attempt is not good enough, according to critics. There are many more important laws where criminal provisions are present, which is hampering business, which is affecting the business environment. So it's only a quasi decriminalization or a half-baked decriminalization. They're also questioning the competence of adjudicating officers in deciding the fines. Officers from the ministries, they may not be technically capable, legally capable to decide the fine under complex laws like the Air Act and Environment Protection Act. You can't expect a junior adjudicating officer from Environment Ministry to correctly decide what's going to be the fine for violating these critical environmental laws. They lack the legal and technical expertise. So that is another criticism. By appointing adjudicating officers to decide the fine, they're pointing out that they may not have the technical competence and the expertise to determine the correct fine. This also creates a possibility of a collusion, a nexus. If the concerned industry is able to bribe the adjudicating officer, then even fines can be reduced. That possibility is always there, right? So all this criticism has been brought up. And also, certain unnecessary provisions are being decriminalized, which has nothing to do with ease of doing business. For example, the Indian Post Office Act. Under the Indian Post Office Act, if you steal any post or mail, if you misappropriate a post or a parcel, right, you're liable for criminal prosecution. This is being decriminalized. Critics are saying it has nothing to do with ease of doing business. Yes, it's an outdated law, but shouldn't have been clubbed with other business related laws. So all these discrepancies have been pointed out by the critics. That these are the major concerns regarding the Jan Vishwas bill. I hope you guys have understood this topic. It's very, very important. Now take up a practice question. What best defines the primary objective of the Jan Vishwas bill? Please read the question. What best defines the primary objective of this bill? To update old laws in line with World Bank standards to reduce delays. It aims at giving a boost to ease of living and ease of doing business by decriminalizing certain offenses. It seeks to push investments in MSME sector through incentives, or all the above. I'm launching the poll. 15 seconds is enough. Go ahead and give your answer. Of course, there's a small typographical error here. This is B, this is C, this is D. I think that's very clear, very apparent. What best defines the primary objective? 37% have said all the above. I was expecting this, but I'm happy that majority of you have got the right answer. 56% of you have said option B. Yes, option B is correct. Let me tell you why the other two are incorrect. The statements are very cleverly designed. Yes, the law is updating the old laws, correct? It is in line with World Bank standards to promote ease of doing business. But that is not the primary objective. It's not looking to reduce delays in ease of doing business. That is not the primary objective here. There is a much better description. That is statement B. Its aim is to boost ease of living and ease of doing business by decriminalizing certain offenses. That is the perfect explanation of the objective of the bill. Third one is also incorrect because it's not giving any incentives. It's not focused on reducing any delays. That's why A and C are incorrect. Even though it looks very close and you're tempted to select all the above as the answer, but A and C are wrong. A careful reading and understanding will let you know that A and C are wrong. It's not focused on reducing delays. It's not giving any incentives to drive investments. It's only B which is correct. By decriminalizing offenses in several laws, it's promoting ease of living and ease of doing business. That's the prime objective. So option B is the correct answer. Now moving on, we have 5 small topics, starting with bedaquiline drug. Bedaquiline drug was in news because of the patent over bedaquiline drug, which is held by J&J or Johnson & Johnson, which is a very popular pharmaceutical company. Bedaquiline is a life-saving drug which is used to treat drug-resistant tuberculosis. It's one of the very few life-saving drugs that we have to cure drug-resistant tuberculosis and to save the life of the patients. Is that clear? Now, the problem here is that bedaquiline was a patented drug. It was patented by Johnson & Johnson. But its patent has expired recently. And the Indian Patent Office has recently rejected the extension of the patent. Johnson & Johnson had applied for an extension. It was trying to evergreen the patent. Evergreening, it's a fraudulent practice used by companies to hold a permanent patent on their discoveries. This allows them to hold monopoly on the product and thereby reap profits. See, when it comes to research and innovation, the prime incentive for any company to invest millions of dollars in research is to get hold of IP rights. That is to get a patent on their discovery, on their innovation. There's nothing wrong with that. That is what motivates the researchers, the companies, the investors to focus on research and development. But when it comes to essential medicines, life-saving drugs, you can't have pharma companies evergreening their patent, getting repeated renewals and extending the patent through minor changes and holding a permanent monopoly on the product. Because patented products are very expensive. It's not affordable to the common man, especially in poor countries, developing, underdeveloped countries. Such life-saving drugs will become inaccessible because they're unaffordable. Now, this is against the spirit of humanity. That is why there are mechanisms to promote generic versions of these patented drugs. One of them is to reject such patents. So Johnson & Johnson's patent on bedaquiline was expiring, and the Indian Patent Office has rejected its extension, which essentially will allow Indian drug manufacturers to produce generic variant of bedaquiline. The non-patented variant using the same formulation can be produced by Indian pharmaceutical firms, and they can produce the generic versions, which will be much cheaper, thereby making this life-saving drug accessible to the common man. So that was the big development. Now, understand few important points about tuberculosis. Because of this, UPSC might ask a question on TB. You should know what is tuberculosis, what is the burden of tuberculosis, and what is drug-resistant tuberculosis. TB is a highly infectious disease. It's one of the deadliest diseases that we have. In fact, before COVID-19, it was considered as the world's most infectious and dangerous disease. It's caused by a bacteria. It's a bacterium-borne infection. Mycobacterium tuberculosis is what causes the infection, and it leads to a respiratory disorder causing pulmonary failure, right? The number of people affected by TB around the world is very high. Every year, millions of people are infected and several lakh people lose their lives. It could turn fatal as well. Is that clear? And especially the burden on developing, underdeveloped countries is very high. It's an airborne disease. It spreads through contact. It spreads in close ranges. Those who come in close contact with the patient, with the infected person, they can easily contact the bacteria either through air droplets or through direct physical contact with bodily fluids. So it's highly infectious and it threatens millions of people every year. That is the high burden of tuberculosis. Countries like India bear the biggest burden. Is that clear? India faces one of the highest burdens of tuberculosis, and it happens to be a major public threat. Now, we have developed effective methods to diagnose TB, to detect it very quickly. We even have the correct line of treatment to cure tuberculosis. But the problem is, due to abuse of drugs, due to the incorrect line of treatment and over usage of various antibiotics and drugs, there is antibiotic resistance and antimicrobial resistance that has built up. The bacterium itself has evolved and mutated, and even human bodies have undergone changes, developing drug resistance. So the basic line of defense that we have, the first and second line of drugs we have, they are becoming redundant. Super bugs have come up, super pathogens have come up, which have evolved and mutated to bypass the first and second line of drugs, thereby creating multi-drug resistant tuberculosis and even extensively drug resistant tuberculosis. Is that clear? It's very common, especially in developing, underdeveloped countries where you don't have good sanitation and hygiene. It allows the pathogens to breed, come out with new mutants and variants. And also, in developing, underdeveloped countries, there is a abuse of drugs, abuse of antibiotics, self-prescription by patients, or patients not completing the entire course. So when you don't complete the course of your treatment, or when you are self-prescribing drugs to yourself without consulting a doctor, right, you're contributing to multi-drug resistant tuberculosis. There are variants which are extremely drug resistant, even to the third line of drugs. So patients who suffer from these devastating conditions, they have no other option apart from drugs like benaquiline. Benaquiline is a life-saving drug, as it can cure multi-drug resistant and even extensively drug resistant tuberculosis. India has the biggest burden. Around 1/4 of the world's multi-drug resistant TB and extensively drug resistant TB is found in India. Is that clear? There are thousands of patients suffering from this. Right now, bedaquiline was very expensive because of Johnson & Johnson's patent. All right, but J&J applied for an extension. It even got an extension in many countries. In around 66 low and middle income countries, J&J had filed for secondary patent, which has been extended until 2027. So thereby, bedaquiline remains expensive, unaffordable in many poor countries. But thanks to few patients in India and their appeal at the Indian Patent Office, the extension of the patent has been rejected, thereby allowing Indian companies to produce generic versions of this life-saving drug. Few patients suffering from multi-drug resistant TB, right, who suffered from the side effect of other drugs, who couldn't afford bedaquiline, they have filed a petition. This patient group, they filed a counter petition at Indian Patent Office challenging the extension of the patent. So the Indian Patent Office has refused to extend the patent of Johnson & Johnson, thereby leading to its expiry just a few days back. And this will allow Indian companies to produce generic versions of the drug, and at least in some countries, in India and few other countries, this cheaper version of the drug can be sold, and thus it could help save lives, that too for patients who are suffering from multi-drug resistant tuberculosis. This is what you should know about tuberculosis and bedaquiline drug. Next, Mahadai Wildlife Sanctuary, another important topic that was in news. Mahadai Wildlife Sanctuary, which is a protected area in Goa, it's a protected area. It's currently a wildlife sanctuary. There is a proposal to establish a tiger reserve at this wildlife sanctuary under Project Tiger. Because in the Mahadai Wildlife Sanctuary, there are around 5 tigers which have been found, and they are seen as a key link between the tiger reserves of Maharashtra and Karnataka. Between the tiger reserves of Maharashtra and Karnataka in the Western Ghats, the movement and presence of tigers in Goa, particularly through the Mahadai Wildlife Sanctuary, is seen as critical for the protection and survival of the species in this region. That's why there is a proposal to establish a tiger reserve here. But the state government was not very keen, because if a tiger reserve is established, it will lead to displacement of people. People residing in the core areas will have to be evicted. Several activities will be restricted. which will affect the livelihood of the people. So based on local demands and local opposition, Goa government was against the establishment of the tiger reserve at Mahadai. Regarding this, a case had been filed at Bombay High Court, at the Goa bench of the Bombay High Court. And recently, the Goa bench of the Bombay High Court has ruled in favor of establishing the tiger reserve. It has directed the state and central governments to establish this tiger reserve under Project Tiger. Now, this development has led to protests in Goa. The local people have opposed and protested against the project. Even the Goa state government is against the establishment of the tiger reserve. It has appealed to the center to not establish the tiger reserve and challenge the High Court's ruling. This development, if it leads to a tiger reserve, it could potentially affect the Mahadai water project of Karnataka as well, which is a standing river dispute between Karnataka and Goa. So that is why it's very important for you guys to know where exactly Mahadai Wildlife Sanctuary is located, where is the Mahadai River, and what is this Mahadai project that Karnataka government is taking up, which is a river dispute between Karnataka and Goa. Let me take you through the key points from a geography point of view, which will help you prepare for any prelims question. Please take a look at the key points. The Mahadai Wildlife Sanctuary is located in northern Goa, in the Satara Taluk, or near Valpoi village. It's present over here. All right. This here is Karnataka. This here would be Maharashtra. All right. You can see the Western Ghat ranges. So Goa already has another important wildlife sanctuary, the Bhagwan Mahavir Wildlife Sanctuary, which borders Karnataka. And the other major wildlife sanctuary is the Mahadai Wildlife Sanctuary. This sanctuary is home to many important waterfalls. All right. It's home to prominent waterfalls like Vazra, Sakla, and Virdi. It is home to several threatened species, including the critically endangered long-billed vultures, which were almost on the verge of extinction. It is also home to several important flora and fauna. It has a moist deciduous vegetation, and it's also a sacred grove, which is home to several rare indigenous trees. Sacred grove is a place of worship. A sacred grove is like a community forest where the local people, the local community, they would have assigned religious value, cultural value to the trees and the forest, and they would be worshipping it. Usually there'll be some temple in such a protected area. The local people will have a religious belief and they worship the trees, they worship the forest. So such areas are categorized as sacred groves. And in Mahadai Wildlife Sanctuary, you have sacred groves as well, along with important species of flora and fauna. Is that clear? So please remember this, including its vegetation. It has moist deciduous vegetation. All right. Now, through the wildlife sanctuary, there is a very important river, that is the Mahadai River, which flows through, also called the Mandovi River in Goa. It's called Mahadai in Karnataka. In Goa, it is called Mandovi. It's one of the important west flowing rivers of India. It merges with the Zuari River at Cabo Aguada to form Mormogoa before it drains into the Arabian Sea. So it's a west flowing river. All right. And the capital, Panaji, is situated on the left bank of the Mandovi. Another key point for your prelims. The Karnataka government has proposed a very important water diversion project called Mahadai Water Project, also known as the Kalasa Banduri Nala or Irrigation Project. The proposal of the Karnataka government is to build two important dams at Kalasa and Banduri that you can see here in the map to divert part of the Mahadai River into the Malaprabha Basin, which is a tributary of the Krishna River. Because see, northern and northeastern parts of Karnataka, like Dharwad, then Bijapur, Bidar, right? Then Gadag, all these places are very arid, semi-arid regions. They have water deficiency. So Karnataka government has planned this project to divert the surplus water from Mahadai, which receives sufficient flow in the Western Ghats during monsoon, by building these dams, Kalsa and Banduri, to divert the water into the Malaprabha Basin, which is in the Krishna Basin. Goa obviously has opposed it as it could affect the flow of the Mandovi River. This has led to a dispute, an interstate river dispute. It has even reached the Supreme Court. A tribunal also has been set up. But Karnataka government is willing to go ahead with the project. Now, if Mahadai were to become a tiger reserve, then it could place restrictions on the project as well, as it could affect the flow of the water inside the tiger reserve. So there are concerns that if the tiger reserve is set up, it could affect the Mahadai project of Karnataka. And Goa right now is against the project mainly because of local opposition by the people. Is that clear? So please be aware of these basic facts from a geography point of view. Next, digital time vouchers. A very important and a small topic from polity. This topic was in news because Election Commission of India has announced that it will be issuing digital time vouchers to political parties in order to ensure that all the parties have equitable time on national media, which is owned by government, that is Doordarshan and All India Radio. As you know, Doordarshan or DD and All India Radio, AIR, these are government owned broadcasting agencies owned by Prasar Bharati, right? They are government funded and government owned media outlets. Now, when it comes to election campaign, there is always a concern that the ruling party at the center will dominate the airtime and radio time by using its control over public broadcasting agencies like Doordarshan and All India Radio. The ruling party which is in power, which can control these government-owned media institutions, it can ensure that it gets more time space, more airtime and radio time during election season for campaigning purposes. Now, this would be an unfair election practice for other parties. For the political opposition, this could create an unfair playing field. That will not be free and fair elections. If government itself is getting more campaign or more campaign time through Doordarshan and All India Radio, it creates an unfair playing field for the opposition parties. So to address this, the ECI is coming out with digital time vouchers. The Election Commission will work with Prasar Bharati and they will issue time vouchers for all political parties. The voucher will be for 5 minutes, 10 minutes, 15 minutes, etc. The political parties then, they can give the voucher to some of their representatives, their chosen representatives, who will be given the air time and radio time to campaign for their party. Now, this will ensure equitable time. It will ensure fair and equitable time space for all the parties. Is that clear? But no individual representative should use more than 20 minutes. That's the maximum time allotted to any individual representative. All right, the vouchers are given to the parties, like to the BJP, to the Congress and the others. The party can distribute the vouchers to their representatives who then can seek space on Doordarshan and All India Radio to campaign for the party. They can get vouchers of 5 minutes, 10 minutes, 15 minutes. Maximum for any individual is 20 minutes, not more than that. Is that clear? For one politician, maximum airtime and radio time is 20 minutes. But each party will be allocated certain time space and they can distribute the vouchers within their party, and this ensures that all the parties get a fair and equitable representation on government-owned media. This has legal backing as well. Under Section 39A of the Representation of People Act, a statutory basis was created in 1998 for this. For issuing such digital time vouchers, a legal backing was created in 98 through Section 39A of the Representation of the People Act. The whole purpose is to ensure fair and equitable access to all the parties on Doordarshan and All India Radio. But of course, in deciding the total time for each party, the party's performance, electoral performance, will also be taken into consideration. The party's performance in the Lok Sabha election, in the last assembly election, will be considered, and it will be available to all national parties and recognized state parties. Unrecognized parties will not get it. All right. Only the national parties and recognized state parties, depending on their electoral performance, they will be allotted a fair amount of time space and given these digital time vouchers. Then the party can distribute this to their representatives, and each of them will get 5, 10, 15 to 20 minutes maximum. All right. So this is the mechanism created by Election Commission of India. It decides the allocation with Prasar Bharati, but ECI is the primary agency to decide as to which party gets what time space on Doordarshan and All India Radio. Is that clear? Next, Tiger census of 2022 was back in news. There are some important facts I would like to bring out, because see, this is a topic we had actually covered in detail in April and May, if you guys remember. Because in the month of April, we marked the 50th anniversary of Project Tiger in April 2023. Prime Minister Modi visited Mudumalai and Bandipur Tiger Reserve in Tamil Nadu and Karnataka to celebrate the 50th anniversary of Project Tiger. And he even released the Status of Tigers 2022 report, which is basically the Tiger census report. All right. Back then, only initial estimates were given. According to initial estimation, there were 3,167 tigers in India as per the quadrennial tiger census conducted in the country. It's a quadrennial census conducted every 4 years since 2008, since 2006, right? We have conducted 5 nationwide tiger census led by NTCA, the National Tiger Conservation Authority, and the Ministry of Environment, Forest and Climate Change. NTCA is the lead agency in conducting the tiger census, which is a nationwide exercise across all tiger reserves. NTCA works with state forest departments, volunteers, and environmental groups to conduct a scientific assessment of the tiger population in the country. It was launched under Project Tiger by the then Manmohan Singh government after tiger numbers had fallen to just around 1,600 by 2005. Tigers were on the brink of extinction in India. Since then, Project Tiger was revived and a quadrennial census was launched starting from 2006. So according to the last census data in 2018, India had 2,967 tigers. Initial estimate from 2022 suggested that we had increased the number to around 3,167, which was a very minor jump. This was just the initial data that was released in April when PM Modi celebrated the 50th anniversary of Project Tiger. But now the final report has come in. The final verified data has come in that gives us the final estimate of tigers in the country along with the state-wise breakup. That's why these facts are important. So according to the full report, the final report, the average tiger population in India has jumped to 3,682, which is an annual rise of 6%. This final report was brought out on the International Tiger Day that was recently celebrated last week. And it means that 75% of the world's tiger population, the wild tiger population, is present in India. Is that clear? Out of the total tigers in the wild, 75% of them are found in India. And the census puts the maximum number of tigers in the country at a high of 3,925, very close to 4,000 tigers. On an average, the average number is 3,682. Is that clear? So please remember the fact. And the state with the highest tiger population is Madhya Pradesh, which has seen a 50% jump in its population in the last 4 years. Its tiger population has jumped to 785, and Madhya Pradesh has the highest tiger population in the country, followed by Karnataka with 563 tigers, then Uttarakhand and Maharashtra. Please remember the top 4 states with regard to their tiger population and the final numbers with regard to India's tiger population. Is that clear? These basic facts can be very important for your prelims. Now, coming to the last topic for today, fast radio bursts, a topic from science and technology. So let's understand what are fast radio bursts, and then we'll conclude today's discussion. Recently, there was an article in the Hindu referring to some latest developments regarding fast radio bursts, which is a cosmic mystery for astronomers. A few years ago, we detected a burst of radio waves. It's a sudden and a short-lived burst of radio waves. It's like a bright flash of light that appears only for a few milliseconds to a maximum of 3 seconds. This flash of light, which is basically a burst of radio waves, it will last just for a few milliseconds to a maximum of 3 seconds. It's quite intense, of course, not detectable to the naked eye, but radio telescopes can pick it up. These fast radio bursts, they hold the answers to the very evolution of the universe. Is that clear? Even today, it's a mystery to us. We don't exactly know the phenomena that's generating it. We don't exactly know where it is originating from. There are a lot of unanswered questions regarding the origin and the phenomena behind fast radio bursts. However, through studies, we have been able to come up with some theories. Based on the theory, the first radio burst was detected in 2007. That was the first detection through a radio telescope of fast radio bursts in 2007. Since then, we have recorded around 140 such events until 2021. Recently, there have been a lot of advances in the field of astronomy, especially in the field of radio astronomy. We have very sophisticated radio telescopes that can detect radio waves, and they can keep an eye on these fast radio bursts. The theory is that they are emitted by stars that are dying. This is the theory. The theory is that these fast radio bursts are emitted by dying stars, and they could hold the answers to understand the formation and the death of a star and the very evolution of the universe itself. Right? Of course, the universe is a mystery. We still haven't unraveled majority of what constitutes the universe. How was it formed? So studying and understanding fast radio bursts through radio telescope is a priority for astronomers and space agencies around the world, because it holds the clue to the life cycle of a star, the death of a star, and the other questions, unanswered questions regarding our universe, including the very formation of our universe. Some of these radio bursts are intermittent. They happen just once in a while. It's like a one-off phenomena. But some radio bursts that we have detected, they are repeating. They are periodically repeating after a certain period of time. Is that clear? So we still don't have a clue regarding how it's originating, what's the phenomena behind it. But the theory is that it's emitted during the death phase of a star, and it originates near the star which is dying out. Right? So since radio telescopy, radio astronomy came out, since radio waves were accidentally discovered by Carl Jansky, it paved the way for radio astronomy, that is studying the universe through radio waves. Right? You can't just rely on visible light to study the universe. A lot of it is not even perceived by humans. So one way to understand the universe is to study the radio waves being emitted. That's why radio telescopes play a critical role in radio astronomy. Today we have sophisticated, very powerful radio telescopes, very sensitive instruments, which can detect the minutest of radio bursts. And studying and analyzing fast radio bursts is one way to understand the death of a star and possibly the very evolution of the universe. All right. So you should have this basic knowledge and awareness about fast radio bursts. There can be a basic question on this. So this completes my discussion for today. I've covered 9 big topics. Let me see if there are any questions, any doubts that are remaining, and then we can close the session for today. Shekhar is asking, Goa bench means judges specially for Goa cases? Yes. Goa does not have its own high court, so the Goa bench of Bombay High Court looks into cases related to Goa. Banu is asking notified price, auction price, and import price means don't get into those details. These are the different prices of coal, which is computed to come out with the price index, the coal price index, the national coal index. Notified price is the price notified by the government. Import price is the price at which we are importing coal. Auction price is the price at which coal is auctioned by Coal India Limited, right? So all the three prices are taken to compute the national coal index. This understanding is enough. Dinesh is asking, if National Tiger Census was started under Manmohan Singh government, then what was started under Indira Gandhi government in 1973? In 1973, Project Tiger was launched under Indira Gandhi government. Project Tiger was launched in 1973. It did see some success, but by 1990s and early 2000, tiger numbers declined due to poor implementation of Project Tiger, and also due to increasing hunting and destruction of tiger habitat. By then, by 2004, 2005, tiger population had fallen to 1,600 plus. It was an alarming number. So then the Manmohan Singh government revived Project Tiger and launched the tiger census as well, and established the NTCA, National Tiger Conservation Authority, to administer Project Tiger. So in the last 17 odd years, 18 years, we have seen a very big success under Project Tiger, and the tiger population has almost tripled, right? It's increased by more than 100%. And today we are touching 4,000 tigers. And that's a big success for Project Tiger. Aniket is asking, is India also looking for fast radio buzz? Yes, ISRO and other institutions involved in physical sciences, astronomical sciences, they're all studying fast radio buzz. The Raman Institute, for example, the Indian Institute of Astrophysics, right? The Physical Research Laboratory and ISRO, they all study fast radio bursts. Okay, so guys, these are the questions. So let's end the discussion for today. I hope you guys have understood all the topics. Do let me know how the session went. Do let me know in the comments. I'll take a look at it, and hopefully I'll see you soon. So till then, take care. Have a good night.